It's a parent's responsibility to financially support a kid. Anyone who thinks, hey, I don't want to hand my ex money, I'm the higher earner, and so I don't want to pay him support, even child support, to continue to sponge off me, you can just hang it up. Who gets custody and who pays child support? And it's a kid's right to be supported. It's a parent's responsibility to financially support a kid. A child has to be housed, clothed, fed, taken places, and there's lots and lots of expenses that go into that. Here are the 5 most frequently asked divorce questions for 2025. I'm Angela Jones, a divorce attorney for about 30 years, and I'm going to answer these questions for you today. Number 1, will you have to pay alimony or can you get it? Number 2, how will the property and debts be divided? Number 3, what about the kids? Who gets custody and who pays child support? Then number 4, how long is this going to take? And the number 1 question, what is it going to cost? If you stick around to the end, I'll tell you how to make sure that you get the fairest and least costly divorce possible. Let's take it from the top. Like, if you don't have a prenup, are you going to have to pay spousal maintenance or alimony, which is basically support for your spouse? Or if you're a spouse who isn't the primary breadwinner, are you going to be able to get it? Now, I'm going to preface all of this with saying I am a licensed attorney, not your attorney, and I'm only licensed in the states of Colorado and Tennessee. So all of this advice, all of these tips are going to be general. Like, I'm not giving you specific legal advice, but this is going to run, the thread is going to run true in all 50 states in the U.S., and which is all states have state-specific divorce laws, and those all include some form of spousal maintenance or alimony, and that's basically support. In certain states, you can get lump sums. In other states, you can get permanent alimony. And all of that's going to depend on essentially the spouse's incomes, their ability to pay spousal maintenance if it's needed, and for how long. The length of the marriage comes into play. In some states, not most, what contributions you made or whether there's any fault. And that's right, there is fault that comes into play in spousal maintenance or alimony in some states. For instance, I believe it's Maryland that if you're found to have committed adultery, you can lose your ability to collect spousal maintenance. Don't quote me on that. Again, I don't practice in Maryland. But I know there's at least, some states where fault factors in. Not every state does that. In Colorado specifically, I can tell you that economics are not affected by misbehavior. In Tennessee, we do have something called inappropriate marital conduct, which can get you tagged a little bit in the divorce settlement. So you have to be careful there. Best facts are that you aren't at fault beyond, you're just not willing to be married anymore. Misconduct's never a good thing when you're asking the court to equitably divide your property, which is what I'm going to get to next. How is it that property is divided? In almost every state, property is divided equitably. So what does that mean? Equitable means fair. Fair in the judge's opinion. That's why most of the time it's best for you to try to work on an agreement to divide your property without going before a judge. That's going to, in general, make sure that the big picture gets more than a look. One of the things that I like to go through with my clients, I take a piece of notebook paper and I'll say, okay, this is everything that you know about your marriage, your debts, your divorce, all of the history that you have, where things came from, who, should get this china because, it came from grandma, passed to the daughter, etc. You fold that piece of paper in half. That's what you're going to be able to download to your lawyer. Okay. Then your lawyer is going to fold that in half in preparing your trial presentation. Then based upon how much time is available to you in court, the fact that that time gets split with the other side grabbing for the judge's attention, and just, a human being's ability to absorb information, that paper is going to get folded in half again, leaving the judge with very little actual information about what is fairest in terms of the overall distribution of what you have. Well, the long and the short of it is the judge is going to look at everything that you own and everything that you owe, categorize what part of it is marital, and then split it up in a way that seems fair. Most of the time, that ends up being equal, at least where I practice. Some of the time, it can be divided unequally, but usually it's not divided unequally if one person was a stay-at-home parent or spouse and the other one worked. In general, what's considered to be marital property is things that were earned or attained during the marriage. Same thing goes with debt. If you racked up that debt, even if it was your spouse and not you, especially on household items, making, the trains continue to move in the marriage, that's going to get divided probably equally. So at the end of the day, if you put everything you own and everything you owe on a spreadsheet and figure out a way for it to be relatively even at the bottom on his side and her side, that's about what you can expect in terms of division of property. The next one is custody. And quite frankly, that is the biggest question often asked, usually first or second when I'm talking to people who have kids. If it's not asked first, it's generally because the parties have already agreed to something like a 50-50 or some type of arrangement that works, or they have older kids, teenagers who they've just decided they're going to kind of let float wherever they want to. But it's critically important that you have as detailed a parenting plan as possible set out for your kids. A lot of times people think of custody just in terms of like, okay, how much parenting time do I get? End of discussion. And there are lots and lots of other details that are really important. This is like your new manual for operating between yourselves as parents for your kids. It used to be that, you're talking about or arguing about many times, what's going to happen with the kids, who's going to take who where, am I going to have this child while you're at work, or who's picking them up, who's dropping them off, who's responsible for bath time. Well, now, whatever time that you have, you're 100% responsible for all the things that happen during that time. But when's Johnny going to go to the doctor? Or what if, his ball game happens on your time or on your ex's time? Who gets to attend those games? Should Johnny be able to have both of you there? Can you handle both being in these places at the same time? Or maybe even more important, what if, Johnny has medical things that need to be dealt with? Who's going to be responsible for those appointments, or who gets to attend the appointments? Do both people get to attend the appointments? Who makes those appointments? And the notice that has to be received. There's a lot of details to drill down in. And this is especially important to, really head off post-divorce conflict. And I cannot tell you the number of times that I've had people come in to have to modify, clarify really their parenting plan with respect to pickups, drop-offs. When does this holiday or break time start and stop? Just because people didn't drill down enough into those details. I will tell you, this is an area that even if you're doing a DIY divorce and you agree on everything, right? To really have a divorce attorney, pay for an hour of time to look over that parenting plan, drill down into those details, see where there's any obvious gaps. I had a gal come to me this past week who literally had no specified information about decision making at all. Like, who gets to make the decisions? No, whether she has access to any information. It was absolutely silent. This was a decree that came out of, another state, a state where I didn't practice. And so maybe that's common practice there. But I'm going to tell you, at this point in time, we're having to, register what's called a foreign decree and go in and ask our court in a different state to provide some clarity on whether or not, dad has the responsibility to engage, include mom in conversations over treatment of their child, and whether mom even has access. Because right now, mom knows the kid's getting treatment because the kid told her, and she doesn't know even where, and dad won't tell her. So here we are in litigation. All of this could have been headed off by including simple statements about mom and dad, have access to this type of information. Both mom and dad get to make decisions, or dad's going to make the decision and he's going to let mom know, what that decision is, etc. Of course, there's the child support piece. Look, most states have a pretty formulaic approach. Where this gets a little complicated is when people have like self-employment income or, hiding income. And there are ways to deal with that. You're generally going to need an attorney if you have those kinds of, difficult to pin down income or income from complex sources like trusts or stocks and other types of things like that. For most people, though, it's pretty straightforward. You take your W-2 income, you take your ex's W-2 income, you plug that in, maybe get some credits for, somebody paying daycare or somebody paying health insurance, things of that nature. Plug in the number of overnights that you each are going to have on a 50-50. That's like 181.5 a piece. And boom, it spits out, your bottom line. Now, one sidebar to that is most states will include spousal maintenance in that child support worksheet too. For instance, if you're getting spousal maintenance or paying spousal maintenance, that income will shift over. So that's a little nuance you want to keep in mind, but it's pretty formulaic, and it's a kid's right to be supported. It's a parent's responsibility to financially support a kid. So, let me just put it out there right now. Anyone who thinks, hey, I don't want to hand my ex money, or, hey, she's not using it for this, or, look, this guy never really contributed, and, I'm the higher earner, and so I don't want to, pay him support, even child support to continue to, sponge off me. You can just hang it up. Like, forget that. You need to think about this as support for your kid. And whether it gets expressly in, line item used for your child, that child has to be housed, clothed, fed, taken places, and there's lots and lots of, expenses that go into that. Two cannot live separately as cheaply, as they can together. It's just a reality of the situation in almost every state in our union is going to require you to support that kid. Think of it as their support, your other parent who you decided to have this kid with, as the custodian over that, and drive on, pay your support. I am going to add in here, though, that when it comes to support, a lot of people aren't thinking about this. And so we will delve into these things. You need to be thinking about tax dependency. Who gets the child tax credit? Who gets to take the child as a dependent in, alternate years? School fees are something that are support. Health insurance is support. Who pays for deductibles and out-of-pockets, things of that nature. Braces, my goodness. I cannot tell you the number of people that have come to me in a, just a conflict over braces. Braces are an extraordinary expense in the United States. They're necessary. Nobody is going to, have their teenage kid with crooked teeth come into a court and have the court not find just because you don't agree with them getting braces that, they shouldn't have them. It's an extraordinary expense. Those things should be detailed out. Extracurriculars, on the other hand, there's a lot of room for negotiation. I always suggest that extracurriculars be either court-ordered or mutually agreed upon in order to put the other parent on the hook financially, because sometimes parents will get their kids involved in things like, in Colorado Springs, where I practice, say Olympics. that the other parent just cannot afford. And so that's a cost cap that really needs to be addressed in your parenting plan. Okay, moving on to how long it's going to take. Well, that's going to depend on your jurisdiction. I would say this is a very good question for people to ask an attorney who practices where you're getting divorced in the courts, where you are, going to have that decision made, because it's very location dependent. In Colorado, we practice in several different counties, and the answer is different if the divorce is contested, depending on the county. For instance, Pueblo and Teller counties move much more quickly than El Paso County. And it's because of the number of divorces that are filed in the county and the judges that are available to hear those. At that same time, whether a case is contested or uncontested makes a dramatic difference in how long a divorce can take. The more contested, meaning the less that you can agree on things, the longer it is going to take you to get divorced. And that is true, period. Conflict, escalating over minor issues, and if it's necessary, look, if there are serious issues that really have to be litigated, by all means, litigate them. But engaging in alternative dispute resolution, such as mediation, which is, mandatory some places, but voluntary almost everywhere, can really help you agree to the things that don't have to be disputed to narrow the issues that you ultimately end up having to take to court. But almost everywhere, you're not going to get a divorce while there are outstanding issues in the divorce. So to shorten the time frame that it takes you to get divorced, I recommend two things. One, that before you ever file a divorce paper, that you sit down, usually with an attorney, and do pre-divorce planning, and you map out your case, what you have, what you want from a parenting perspective, from a financial perspective, because those are really the two big things, kids and finances. Even so, go so far as to draft up the parenting plan or an agreement to dissolution agreement before you ever file the paperwork. That way, you can be proactive, you can be responsive once the paperwork's filed, never reactive. You already have your ducks in a row, and you're never acting under pressure. When people are faced with decision making in the middle of a divorce, they're dealing with their fight-flight response at those times. And that's not when we make our best decision, when we're in monkey brain, when someone's coming after us. If the decisions have already been made, and you know that you're really just having to enforce your boundaries, you've already talked it through, you've thought it through, you've made the decisions about where your bright red lines are, then it makes it a lot easier for you to, basically hold your position, kind of be a gray rock. If you're dealing with someone who's a narcissist, really trying to get a rise out of you, trying to upset you, punish you in some way in the divorce, you're very able to just sit there and not be reactive. You said what you said, and that's that. You know what you're going to go to court over. You know what you're not going to go to court over. And it makes things very clear. We can agree on what we can agree on. We can agree to disagree and let the judge decide the rest. Okay, and that brings me to our number one, absolute number one question that we get. And then, in fact, I'm in a group of family law attorneys that work with the same marketing company, and we talk about, the people that call us and, how to handle those calls, how to best handle those calls so we can help the most people on an ongoing basis. And they'll get on the phone first saying, hey, I just want to know how much this is going to cost. How much is this going to cost? It's constant. Like, okay, all I want to know. And here's the deal. That's like driving your car up, to the front of an auto mechanics and saying, hey, something's wrong with my car. How much is this going to cost? There's absolutely no way that anybody can tell you until they get in there and lift up that hood. And then it's going to depend on, not only what we find under your hood, but what we find under your ex's hood. Are they reasonable? Are they amiable? Are they trying to, get it done as quickly, as fairly, as cost efficiently as possible in the same way that you are. So here's what again, going back to my last recommendation, which is the pre-divorce planning. Okay, that's one way that you can minimize your costs. I will tell you, just as an example, in our Colorado office, our Colorado divorces on average are in the neighborhood of 25% less expensive than the Colorado average because we do the pre-divorce planning. I attribute it directly to that because we don't spin the case up, talking and being, volleying back and forth with opposing counsel or the other party when it comes time, to negotiate. We know what we're doing and our costs are capped in that way. And we're already prepared for the hearing on the issues that go contested. And that's done from the beginning. That's one way. But the key to that working, and this is the trick, I told you I would tell you how to have the fairest and most cost-efficient divorce, is reasonableness. You must come to the table reasonable. And here's how you get to understand what is reasonable and what is not. It's by going through that pre-divorce planning with an attorney. And that's going to be my very best recommendation to you. Not every divorce needs an attorney. Most definitely, not every divorce needs, an attorney to represent them or actively negotiate on their behalf. But I think everyone is best served by sitting down with an attorney in their jurisdiction, laying out soup to nuts what exactly is going on, laying out the paperwork, having that reviewed, making sure you're not missing big holes that are either going to cause problems in your divorce or post-divorce. Because let me tell you, divorce attorneys make a lot of money, fixing mistakes in DIY divorces or just fixing stuff that didn't get really nailed down, in the first go, either, by counsel who are trying to deal with combative litigants or, by a judge who's doing their best from the bench to, kind of give you like new operating rules for your new family situation. So it is to sit down, spend that time on the front end to figure it out. Now, that may not always be possible if, like, say you got served with divorce, but the same serves true. As soon as you get filed, that get served those papers, book an appointment to sit down with an experienced attorney in your jurisdiction and nug it all out. Get real settled on where you want to, come out. I will tell you, for me, if a person comes to me in Colorado and says, hey, I have a parent who, has been co-parenting with me, has actually maybe even been the primary parent, but, I think they're a little crazy. I leave them with my child every day when I go to work, but I think they're a little crazy. So I want to get primary, custody. I won't even take the case because that's not reasonable. I will tell them, hey, listen, that's not a reasonable position. Here's what you have to understand about the way Colorado law works relative to that. Again, your state may have a very different standard than Colorado does. But in Colorado, if there's not something wrong with a parent, meaning, they're a danger to their child, there's a provable issue relative to their ability to safely be around their child, you're not going to have them restricted in terms of their time with, that they get to spend with your kid because you guys don't get along. They'll see that for, exactly that. You don't get along. You two are getting divorced. This child still needs to have time with the other side. So it's not going to be a reasonable position to take to try to cut a parent out of another parent's life. It's just not good for kids. So be reasonable. That's the trick. And I'm going to tell you, every good divorce firm that I know of, like the ones who really know their stuff, who aren't going to churn your case, drive your cost up, basically get off on, the conflict of divorce. And believe me, they're out there. These bulldogs that people are looking for, like, oh, I want someone who's gonna, fight, okay. Some people are just combative. The people who were told, oh, you love to argue all the time, you should go to law school. There are some of those folks who did, in fact, go to law school, and they're practicing family law in our jurisdiction, matter of fact. And nobody likes to work with them. They make cases worse. Best outcomes for families are when, you get through divorces smoothly, by agreement, quickly, because you're in agreement, and it is fair, although maybe a little painful, because the nature of compromise is that nobody gets everything that they want. And the kids, if there are kids, they are prioritized. That you've come up with a good, solid, detailed working agreement that will allow you, if not to co-parent, to parallel parent, so that both parents get to stay as active as possible, naturally parenting their kids, despite the fact that the grown-ups couldn't keep it together.